All right, everyone. I know we have a few more people coming in, but I do want to get started so we have as much time for our wonderful guests as possible. So thank you for taking a break from your regularly scheduled day to attend this very special event. Not only is it a book talk, but it is a conversation between our colleagues. I am Kasaskowski, co-acting director of the Law Library, and it is my distinct pleasure, especially as part of the legal writing and research team, to welcome you to this very special edition of the Faculty Book Talk with our featured author, Diana Simon, Associate Clinical Professor of Law, in conversation with Susie Salmon, a Director of Legal Writing, Clinical Professor of Law, and Distinguished Public Service Scholar, to discuss Professor Simon's new book, The Case of Effective Legal Writing, Court Opinions, Commentary, and Exercises. Diana Simon currently teaches legal writing, analysis, persuasion, and advocacy. She has been teaching at the law school for over 20 years and has taught various classes to first, second, and third year law students. She brings with her over 23 years of experience as a practicing attorney and has worked in Atlanta, Chicago, Washington, D.C., and Los Angeles and Tucson. She enjoys mentoring students, seeing them develop into successful professionals. She is a graduate of Washington University in St. Louis and Emory Law School, where she was notes and comments editor of the Emory Journal. Susie, in addition to leading the legal writing program, also coaches the Colleges of Law's ABA National Appellate Advocacy Competition teams and supervises the Writing Fellow program. She is a prolific writer herself, having written a popular monthly column on legal writing, The Legal Word, in the Arizona Attorney, the magazine of the State Bar of Arizona. And she frequently presents to local, national, and international audiences on issues related to legal writing and advocacy. A nationally recognized expert on moot court, Professor Salmon co-authored the Legal Writing Institute's Moot Court Advisors Handbook, which, sneak peek, will be featured at a future book talk. But with no further ado from me, because I'm not who you're here for, I cede the floor to Diana to make the case of effective legal writing.
Okay, thank you. First, I want to give some shout outs because last book talk I didn't, and I got in trouble with some students. So I have 5 generations of writing fellows here today. So I have Ashley Brick, who's on Zoom, who's already a partner in a law firm in Colorado. I have Vinny and Rose, who came all the way down from Phoenix to be here. I married them. Remember, I told my classes how I officiated at various weddings. This was one of them. And see what happens. They follow you wherever you go. And then I have my current writing fellows up here and my writing fellows from last year. Are you still in that? Okay, they're in trouble. They were not being careful. And anybody, am I missing any writing fellows that what? Oh, Molly. Hi, Molly. I'm giving you a big shout out later on. I want to thank the faculty members that are here. It's like we're doing great. Oh my gosh. Okay. And so I want to thank first and foremost Professor Salmon for agreeing to participate in the second book talk with me. I also want to thank my co-author, Mark Cooney, who's on Zoom. Mark, do you want to wave hello so they know who you are? He's still alive. He still survived being co-author with me. And I want to thank Molly Case, who's there on Zoom. Molly, do you want to wave? She is now clerking for the Arizona Supreme Court. She was my former writing fellow, my senior writing fellow, my research assistant, and so much more than that. But she went through every word of this book. She basically wrote the teacher's manual. She's co-author. And when CAP, Carolina Academic Press, said, we'll publish your book, Molly was the first call I made. And she came over to my house the next day with a bag full of all of her case books. And I was shocked that she actually read them all, but she had read them. And she proceeded to say, this is what I like about this one. This is what I like about this one, because I hadn't seen a case book in, 5,000 years. So she was instrumental in helping me on that. She also brought a unique perspective with her as a student, which obviously as great as Mark is, and we didn't have that perspective as a student. I want to thank my husband, Don Tringali, who's sitting right here, who's my rock, and was very grateful that I had Mark and Molly to work with this time around, so I could basically leave him alone through the process. My sisters are also here and friends are here, so thank you for coming. My sister's here, and I've got one and her husband on Zoom. Okay, that's it.
Okay. So, I mean, speaking of, people to whom you owe great appreciation, this is a really great idea, this book. Where did you get the idea?
So, as most of you know, this is my second book. So my first book contains some case excerpts. And so, but it wasn't full of case excerpts. And so Professor Salmon said, I love that part of your book. I think you should write a whole other book with nothing but case excerpts. And I should have said, why? I just finished this book. Why would I want write another book?
You did say that.
But I pretty much do what I'm told to do. So I wrote this book. It's the first of its kind, a case book for legal writing. And its purpose is to prove that style and mechanics should not be afterthoughts, but to prove that failing to master these skills can have legal consequences and actually make or break cases. I think we always try to impress upon students how clean and error-free their work should be, but this makes the case, pardon the pun, with actual proof. As we say in the book, it's a text that connects legal writing techniques to real-world consequences and brings the courthouse to the legal writing classroom.
So you mentioned that your co-author is here on Zoom, Mark Cooney. So how did you go about finding your co-author?
So there's a list of co-authors, and I got to A, B, and C, and I was exhausted by C, so I said, I'll just pick Mark Cooney. No, that's not how that happened. I did some investigation to see if anything like this had been written before, and found that there was no textbook like this. But then I found an article that Mark Cooney wrote published in Scribes, which is one of the leading voices in the field of legal writing and analysis. And Mark was editor-in-chief of that journal for many, many years. But he had written an article published in Scribes in 2012 called Style is Substance, Collecting Cases and Showing Why It Matters. So I was deflated in the sense that somebody else had this idea before. I wasn't the first. I guess I should say you weren't the first. But I was also excited because I thought, well, this must be a pretty good idea because somebody else had done something like this. So, and I knew Mark because he and his board accepted and published an article I wrote on writing a legal hypothetical in Scribes. So I knew him from working with him on that article. I found him very easy to work with. So I call him up and we have a Zoom, and in the middle of it, Mark, correct me if I'm wrong. He said jokingly, maybe I should be your co-author. And so we got off of that Zoom, and I think I probably went back and talked to Professor Salmon and my whole team because I tend to, vet everything with them. And I decided, well, maybe this is a really good idea. So I called him back, and he agreed to be my co-author. And I think a couple of key reasons why I thought he would be an ideal partner for me, and I don't mean that way, honey.
You already married those two.
One key factor for me was I had read his work, And one thing that we both have in common is that he writes in plain English. His writing is accessible and easy to understand. So I knew our writing styles would gel well. It didn't hurt that he had written a book before. He's published more than 50 articles or books in chapters on legal writing. He's chair of his own department at Thomas M. Cooley Law School, and his work has been cited upon and relied upon in both state and federal courts in many decisions. So I knew he would be a great partner for me.
So before we get into the substance of the book, I want to ask you a couple of process questions. So this is the first time you have co-authored a piece, a book, but I think anything, right?
Right.
So how would you compare the process of writing your own book to writing something with a co-author?
Okay, Mark, can you cover your ears for just 1 minute? Okay, so I would say there are pros and cons. One pro of working alone is that I happen to have a very odd timetable. I'm looking at all my writing fellows. Where if somebody gets someplace on time, like Professor Schwartz did today, that to me is arriving late. So when I'm on my own timetable, I can get done things as fast as I can possibly get them done and beat deadlines. The other significant pro about my first book is it was all me. It was my goofy style. Look, there's a giraffe on the cover. You know, I included cartoons and told my personal story. So that was the advantage. But collaboration can make for really improving and expanding your work. So I think the most significant advantage of collaborating is that it's really nice to have someone that you respect who's in the same field, but has had lots of different experiences from you to brainstorm with. And then we each had our own resources. So Mark's been in the legal writing community many, many more years than I have. But he knows a lot of people, and he would run things by when it came to the title or the cover. He would run it by people he would know. I would run it by my team. And so we expanded the number of voices who contributed to the book. And the other thing about Mark is his contacts. When we were thinking about who could review the work, I had just gone to the well with asking colleagues to review my book, and I didn't want to go back to that well again so soon. So Mark knows top people in the field, and one of them is Judge Leibovitz, who is here. Hi, Judge. So he is acting Supreme Court Justice in Manhattan and president of the 300-judge New York State Association of Acting Supreme Court Justices. He's written 8 books, and you can correct me if any of this is inaccurate.
I got elected to Supreme Court, so I'm not enacting anymore. And I'm so happy to be here with all of you.
Oh, okay. Thank you. Okay. So he's published hundreds of articles, and I've cited him hundreds of times in my work. And always afraid I would misspell his name because it ends with an S, not a Z. But I don't know him. This is the first time I'm actually meeting him in person. And so he agreed to write a review of our book, which is going to be published very soon in the Journal of Appellate Practice and Process. Oh, by the way, he also teaches part-time at Columbia, Fordham, and NYU, and a lot of other things that you do. But I think one of my proudest moments, it was reading his review where he said my first book was one of his favorite legal writing books, and I didn't even know he'd read it. So thank you for saying that. I don't know if it's true, but it doesn't really matter. Thank you for saying that. But all of this happened because of Mark.
Mark is here on Zoom, and Diana, I've worked with you for a long time, over 17 years, I think, all told, and that's a lot of 3 a.m. emails. So I have to ask Mark, Mark, what was it like working with Diana on this book?
It was great. It was great working with her when she published her article in the Scribes Journal, and I'd been enjoying reading her writing, and I enjoy her voice. And we're really peas in a pod I mean, you know, I think, you know, worrying about comma usage that's a good afternoon for me. I think that's just life is good. And so I thought she'd be a perfect fit. And uh, so I felt as if I almost elbowed my way into the project because I thought it sounded so exciting, and I hadn't had the courage to actually turn it into a textbook back in 2012. So it's just a very long article. But the fact that Diana was interested in doing this made me think, well, yeah, maybe this is doable. But Diana's got to be the best lawyer ever, because my gosh, she knows what a deadline is and she knows how to get things done on time. And I did what I was told and I met my deadlines.
Okay, I do, quick break. I forgot to introduce my son. And I think Michael, you want to wave hi? You can't see his head, but he is there. Is
Hello,
Alex
everyone.
here
Yes, I'm
too?
here.
I think Alex is on here too, but.
Yeah, she's on.
Okay. Hi, Alex. My daughter-in-law is here too. Hi, Brielle, another writing fellow. That's second generation, not third generation. Okay. Okay, sorry.
So, you know, speaking of Mark, did you write each chapter together or did you kind of split up the chapters?
Basically, we split up the work. But as editor-in-chief of Scribes for all those years, I think Mark was instrumental in editing the whole book together to make sure our voice was the same. And then Molly also went through the whole book to make sure she's a perfectionist, which is not something I am. But Molly went through the whole book just to make sure our styles were consistent throughout as well. But that's how we did it.
Okay. So how did you decide who was going to write each chapter?
I don't remember how we decided that. I think we did the table of contents. I think I gravitated towards the chapters that were along the lines of the articles I've written before that I write for Arizona Attorney, the State Bar Magazine here, and in my book where I could add a lot of fun, a lot of flavor, a lot of stories, things like that. But I really don't remember exactly how we divided that up.
So how did you decide what order you would present the chapters in?
So Mark basically decided, even though he thinks I was the boss, he was the boss. We placed the chapters that were more in depth on style matters first, and then we followed that up with grammar and punctuation matters more towards the end of the book.
Okay. So as you mentioned, you have 2 books. If people are deciding between your 2 books, I don't know why they wouldn't just buy both, but how would you describe the differences between the 2?
So the not too serious guide is a fun and lighthearted approach to learning about grammar and punctuation issues. The punctuation marks are characters in a story. There are some case excerpts, but not every chapter has case excerpts, and it has cartoons, which this book does not have. It also addresses some stylistic issues like transitions, using cognitive science to prove the importance of those, and it addresses parentheticals and parallelism. Those chapters, those topics are not in my new book, in our new book. Our new book, because it's a case book, includes notes after each chapter. It's completely full of case excerpts, and it has substantive style issues like verbosity, ambiguity, and run-on sentences. We didn't want this book to simply be a reboot of my first book, so it is different.
Ever going to write about nominalizations?
No, she's been bugging me to write about nominalizations like for 5 years.
Okay.
So I'm not going to write about those.
Well, all right. So how did you go about selecting the cases that you used in this book?
So Mark and I talked a lot about that, and I think Molly was part of those discussions too. We decided to the extent possible to pick more recent cases, all from the 2000s. We did our best to pick cases that students, even first-year students, particularly first-year students, could absorb well. So we heavily edited those cases to make sure they were an easy read for students. We avoided any cases involving pro se litigants. We wanted to only use, because we wanted to focus on lawyers who should know better, who were making mistakes. And we also tried to avoid, to the extent possible, any cases dealing with gory subjects that might, because we didn't want to offend any students or trigger any sensitivities in students.
So I know when I was reading the book, I was actually surprised how many cases there were. And I know there are many more cases that you didn't even use. So when you were doing the research, were you surprised by how many cases you found?
Not really, because I knew from my first book, where I included a lot of case excerpts, that there were a lot of cases out there. And then, and Mark had included a lot of cases in his older articles. So, and secondary authority talked a lot about cases too. So I knew there were a lot out there.
So one thing that the two books have in common that I found interesting is both of them tell a lot of stories where punctuation marks are the main characters. So first, you know that commas are not self-aware. I mean, at least they aren't yet. That may be coming, I don't know. But in all seriousness, why did you adopt this strategy in writing both books?
So I think in my first book, I might have told the story, or I certainly did in other articles, about our mother. And we could have a whole session on our mother. And since my two sisters are here, why not? But she was an English teacher, and she, and you might have absorbed everything as the oldest, but I wanted none of that. I didn't want to know anything about grammar and punctuation. I was very busy. I wanted to be a secret agent. So that was not, comma placement was not going to get me there. And so I did not learn it well by just reading a black letter rule on this is where the comma goes. But we know from science that when you tell something in the form of a story, it really absorbs in your memory. So I thought, if I can tell a story about a comma or a semicolon, maybe that'll get into people's brains better. One of the chapters talks about how West Virginia formed its own state and separated from Virginia, and whether this was lawful or not turned on a semicolon in the Constitution. And so that proves a semicolon is not just a semicolon. In fact, the semicolon in that constitutional provision was misplaced. It was in the wrong place. And so what the Supreme Court did subsequently was quote that provision from the statute, but move the semicolon without telling anybody. So just to correct the problem. And if you're thinking, well, the framers of our Constitution didn't really care about grammar and punctuation, that's not true. They had a committee of style and arrangement that managed punctuation, capitalization, and other matters. And the other reason why I wanted to use these cases is that I'm an advocate, like deep down, I'm an advocate. And I wanted to prove to students that, which I still think I have a lot of convincing to do for all of you, but I will keep trying, that it's not just a comma, it's not just a semicolon. This can have real impact. In chapter 8, for example, I talk about how one comma created an ongoing controversy involving climate change for countries around the world. There's an old saying that life can turn on a dime. Well, climate change can turn on a comma.
Speaking of punctuation marks, you have a whole chapter on the apostrophe. So explain that.
Okay, so I've seen, no offense to anybody out there, a fair number of mistakes in apostrophe usage in student writing. In fact, Molly, I'm bringing you up again. Molly, if you have any complaints about the spring problem, I will provide you with her email address so you can complain directly to her about it. But she, and I don't know if I told you to do this or you decided to do this just to get to all the first year students, but notice how the characters in that story are named Williams, and alley-oops. So I cannot wait to see all of the apostrophe errors that are gonna happen with the possessive use of that. But anyway, so the chapter is called Apostrophe Catastrophe. And I used an example of a defendant who argued the trial court erred in denying a motion to suppress evidence based on an apostrophe. The trial court had found that the officer apostrophe S, singular, entry into the house was by invitation. The problem was a lot of officers had approached the house and entered. So the defendant argued that those other officers had no permission to enter. On appeal, the court held the evidence should have been suppressed because under the court's order, while one officer had permission, the other ones did not. In a concurrence, the trial court, the appellate judge said the use of the singular in the trial court's order was important. But there was a blistering dissent that said the conviction should have been upheld and cases should not be decided on the location of an apostrophe. So, and in the notes and questions section, I refer to more interesting tidbits about apostrophes because apostrophes are actually political animals. I don't know if you knew this. So they show possession, like John's book, which makes it seem like somebody owns that book. So some countries have argued that the use of the apostrophe is tied to imperialism. And in Quebec, Canada, some view an apostrophe as a sign of Anglo-imperialism against French Canadians. So you'll see a lot of geographic rivers and cities there, like St. Mary's, where there's no apostrophe. We actually have in the United States, a board of geographic names, if it's still, I don't know, maybe it's been abolished by now, but anyway, it has also issued guidelines on apostrophes. And for example, it discourages apostrophes. And so places like Pikes Peak have no apostrophe, and that's why. Interestingly, there was an article that I edited. Where's Professor Dysart? Okay, for the Journal of Appellate Practice and Process, where the authors tracked the use of apostrophes by Supreme Court justices. They cannot agree on apostrophe usage. So for example, for the state Kansas, let's see, so Justices Thomas, Breyer, Ginsburg, and Sotomayor use only an apostrophe, so Kansas apostrophe for the possessive. Justice Kagan uses an apostrophe S, so they disagree on that. If anybody cares, I agree with Justice Kagan, and so does Brian Garner, and he talks about that in the Red Book.
So of all the different cases that you discuss in the book, do you have any favorites?
So one of them is the Supreme Court's recent decision in 2023 in Barton-Werfer versus Buckley. The issue involved Congress's use of passive voice, which created an ambiguity in a bankruptcy code provision. The bankruptcy part of it was not the interesting part of it. The interesting part was that the court used an example of passive voice that I thought would resonate with students. They said this, Jane's clerkship was obtained through hard work. And the court said that's passive voice. Was it Jane's hard work that got her the clerkship? Or was it someone else's hard work, such as a professor who wrote the letter of recommendation? Or was it a counselor who collated the application? This is from the US Supreme Court.
Justice Barrett.
Yeah, you can't tell, the court said, because the use of passive voice pulls the actor off the stage. So the other case I enjoyed reading about is in a chapter called Semicolons in the Succession of West Virginia. That case involved a nursing and rehabilitation center and interpretation of a federal regulation on how to cook an egg in a nursing home. So the issue was whether nursing homes are required to cook an egg at 145 degrees for a certain time, or whether the requirement was also to make sure that the yolk congealed completely. Maybe because I'm not a cook, but I can make eggs. I don't want to hear it from my husband because he's going to say I can't I can't turn it, I can't do that, but I can, okay.
You can boil it.
I can boil an egg. Okay. So, but the entire case focused on how to cook eggs and the ambiguity created by a semicolon. Also, my favorite cases in the book are those in which a court referred to a legal writing class, either when they sanctioned a lawyer or how the lawyer did in their work. So in one case, the court sanctioned a lawyer to complete a continuing legal education program and had to take 10 hours of legal writing. There was a contract case where the court noted that if the drafters of the contract had been students in a legal writing class, their grade would not begin with a P. And in another case, the court said the summary judgment motion was so poorly written that if a first-year law student had submitted it in a legal writing class, the professor would have encouraged the student to rethink his or her career.
Now, none of us would ever say that.
No, it's not.
But so you use a lot of different cases and you use cases from all different areas of the law. Like I thought, well, maybe these are going to be a lot of like attorney discipline cases, but no, they weren't. They were contracts cases, criminal law cases, statutes, regulations, etc. So why did you choose such a wide array of subject matters?
There were two reasons. First, the idea is to convince you all, students, that it doesn't just crop up in one kind of case. These issues crop up in every kind of case. Also, students have different interests. So maybe a case involving a gun possession statute isn't of interest to you, but maybe you're interested in a case involving a will, or maybe that doesn't sound that exciting, but a bankruptcy case or some other kind of case.
So the last chapter in the book, so you end the book with a chapter about how courts sometimes ignore poor grammar and punctuation. So why did you include that at all? But why did you end with it? I mean, doesn't that undercut your argument that students and lawyers should pay close attention to grammar and style and punctuation?
You're right, and that's why we moved that chapter, which was originally at the beginning, to the end, because if you read that, then you have no incentive to read the rest of the book. But I think it was for my desire to be 100% accurate with students.
You have to disclose adverse authority.
Exactly. And I know you all, and I know if I make a mistake in the book, you'll come to me and say, hey, but what about this case? I read this case and it said grammar and punctuation didn't matter. So I was trying to stop that from happening. Not that that's a problem, it's fine. So I started with an example of a constitutional provision, the 26th Amendment, which if interpreted literally based on the presence of a comma, would treat anyone 18 years old or older as a citizen of the United States without any other qualifications. But despite this comma error, no one has ever argued to the contrary. I'm just afraid to say all of these things now because I swear I did all of this before citizenship was an issue or anything like that. But in a 1925 Supreme Court case, the Barrett decision, the court emphasized that punctuation is minor and not controlling, and the court will disregard it or rewrite a statute if the punctuation is wrong. Interestingly to me, this comes from a time in history when male lawyers were writing articles about how punctuation was a woman's job, and stenographers, who were all women at the time, were deemed unimportant. Their job was to dress sentences, quote, with the lace and ruffles of punctuation. But this chapter quickly pivots back to the importance of style with some more modern cases, but that Barrett decision has been cited as recently as 2009. In a 2009 case, the Massachusetts Supreme Court ignored errors, comma errors, and belittled the comma placement, which was wrong, and quoted Barrett and said, quote, to paraphrase a statement attributable to Sigmund Freud, sometimes a comma is just a comma. So I love that. So the court ignored the comma.
Okay. We've talked mostly about the cases that are in the book so far. But like other case books, this text also includes, as you mentioned, notes and questions, like the note you mentioned from the apostrophe chapter. So how did you go about writing those and deciding what should go in those?
Okay, so I came up with a draft, but Molly helped a lot on this because I always hated those questions in case books when I was in law school. So they just made me nervous. Some questions related directly to the cases we excerpted for students. So for example, in the active voice chapter, when courts came out differently on the passive voice issue, we said, are these decisions consistent? Why or why not? Or we would ask, do you think the party expected this outcome? Or we would say, how would you rewrite that provision to avoid this ambiguity? We also included hypothetical situations and asked students to evaluate, is passive voice preferred in this situation or not, and why?
Okay. So at the beginning of the talk, you thanked Molly Case for, among other things, co-authoring, or as you put it, basically authoring, the teacher's manual for the book. So tell us a little more about that teacher's manual, what is in it, and how that came to be.
Okay, so Molly actually helped co-write the teacher's manual that I did for my first book. So I'd already had that experience with her. She did a great job on that. But again, the beauty of Molly is that she could write the manual from the unique perspective of a student, which no matter how we tried, we couldn't put ourselves in the shoes of students. And so as effectively. So for example, for the plain language chapter, Molly had the idea to include an exercise where students are offered a wide variety of concrete real-world examples of the dangers of overly legalistic language and the benefits of plain language. And one class idea she came up with is to discuss the benefits of plain language in contexts that you all are familiar with. Things like leases, car sales contracts, health insurance applications, online service agreements, testing registration forms, such as the LSAT or MPRE. So I don't think I would have thought of those things, but that's what Molly came up with.
So because this book is a case book, I'm assuming that you envision that at least in some instances, it would be used as the textbook for a law school class or maybe an undergrad law class. So do you have any tips for professors who are thinking about how they might teach from this book or assign it as a required or supplemental text, or tips for students who might think about, well, maybe I get this book and it'll help me do better in legal writing. How might I use it?
So I know there's at least one professor. Mark, have you reached that professor?
I haven't caught up with him. He's been using it, I think, for his first and second term classes, but I have not caught up with him.
Okay, so I know at least one professor who's using this as their sole text, but as a supplemental text, I think we could use it much the same way we use my other book, which is to supplement what you're learning and still have time to teach CREAC and the other core subjects that we're teaching. As far as students who want to improve their writing, I will call out one of my writing fellows. Peter, you want to raise your hand? Okay, Peter, I got his permission to do this. Yeah. So he was in my fall class and he used the word ergo in his writing. And I called him out on that. I didn't call him out on that. He called himself out. You added yourself. And so now I really don't know his name, but we just call him Ergo. And so, but I would have directed him to the chapter on the power of plain and the hazards of legalese. I have another student who couldn't be here today, but she was my writing fellow a few years ago. She used the word contrarily. Again, she outed herself. I didn't, but I commented on the contrarily. It turned in, she became my writing fellow after that. She's now clerking for the Ninth Circuit for Judge Desai. And I'm pretty sure it's because she never used the word contrarily ever again in her writing. So again, I think I would direct students to those chapters that need that help.
Okay. So one thing that also jumped out at me as I read the book was how much it showcased different types of legal writing. So we talked about different subject areas, but also different types. So not just or even primarily litigation focused writing of the type that we do in our first year class. You mentioned examples involving legislative drafting or wills or contracts. And not that legal writing professors aren't already struggling to cover everything we already need to cover with limited time and units. But based on your research into the types of legal writing mistakes that make a difference, the ones that are outcome dispositive, that lead to problems, in litigation or have consequences for clients. And I already hate myself for this question, but do you think we should be trying harder to get more transactional type drafting into our mandatory first year legal writing class?
Okay, so many parts to that. So first, I think all of the principles that we teach about plain language, clarity, brevity apply equally to whether you are drafting a will, drafting a contract. So it's not, that goes across disciplines, not just writing the things that we write. Second, we do cover statutes in every year, and we talk about those and clarity. We talk about settlement agreements when we talk about mediation. So that's a kind of contract. And every year we introduce the fundamentals of contract drafting. But yes, if we had all of the time in the world, if we could go from a 2-credit class to a 4-credit class, we could. There are a lot of things that I think we would all love to incorporate. I just updated the plagiarism workshop to include a section on generative artificial intelligence. And I would love to spend weeks in first year legal writing, first writing something on your own, and then taking that same process and doing it all through generative artificial intelligence, only after you have completed that on your own, but there's just no time. And I think there are whole courses on these subjects. I know somebody sitting here now who teaches contract drafting, my husband. I don't think I would be capable of, I've never drafted a mergers and acquisitions agreement, so you don't want me teaching that class. And by the same token, he would not be very good at teaching.
No, I'm not sure.
He thinks he would, but he wouldn't. And there is a whole course on AI, which Professor Laskowski teaches. So, these are, and legislative drafting. So these are other full courses with with credits. Yes.
Well, anything you want to add about the book before we open it up to questions?
No, have I given everybody a shout out? I don't want to hear, Chris Luke, another writing fellow. Hi, Chris. He's that 6th generation. No, he's not, but he's not showing his face. Thank you for showing.
I think we should have a conversation about what the word generation is. Right. So with that, does anyone have any questions for Professor Simon, either in the room or on Zoom? Yes, Professor Lett.
What are you working on next?
Well, I'm not going to talk to Professor Salmon for about 6 months. That's number one. In case she has another idea that she wants to. No. I am working on an article which is not related to any of this, on the importance of failure and making mistakes and learning. I have talked about that to some extent with my fall class, with my dumb questions, insistence that they ask dumb questions and phrase it in that way. And that got me interested in that whole theory about learning. There's a few more other articles that are in the works, just at the research stages, but yeah, I don't think another book is coming anytime soon, which is why I'm glad you're here, because I don't think there'll be another book talk.
Well, and of course, if people want to read Professor Simon, your articles are still appearing in Arizona Attorney Magazine and on Law 360. So, and those are nice and short. So
yes, and I always take it's always student inspired. somebody says something and then it turns into an article. So that's happened many times.
Brielle would like to ask, what was your favorite part of, or one of your favorite parts of writing this book?
Probably work, I mean, although it sometimes drives me crazy to work with other people, I think it also I know it drives her. I think just getting to collaborate with somebody in the same field, but not at my law school, was really interesting for me because we teach the same thing, but sometimes we called it different things, and just interesting to talk to him about how his law school operates and just his ideas. That was great. And I also working with Molly, which it's always great working with Molly, but I think that's probably the highlight for me. Professor Schwartz.
Hi, Professor Simon. Thank you for doing this. This is great. Question on your process. So like, I feel like every time I have to write something, sometimes I'll like print everything out, and highlight it, take notes, or I'll just look at it on the computer and type it out. Do you have any tips on what's worked really well for you, like organizing your research, taking that research and putting it in an outline or in the paper? How do you do it?
So I think I have a habit of ignoring all the advice that everybody gives you about writing. For example, I don't outline my work, which is why I always tell students, do what works for you. I did try on this last article to follow to the T advice in this book on creating scholarship. I tried to do everything the right way with charts and blah, 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 and keeping track of everything. And it took me 4 times as long to do it. And I don't know that the product was any better. So for me, it's, I do all the research. I do all my own research. I take notes on all the research. I try to figure out what points I want to make, and then I pretty much throw everything, like I always say I vomit on the page, and it's a horrible, horrible first draft. And then I refine as I go. I know that's not, but getting up at 3 a.m. really helps too. A lot of extra hours in there.
But what time do you go to sleep?
Early.
Jack, you had your hand up.
Jack.
A Supreme Court justice or any other jurist who you really appreciate their use of grammar in their opinions.
You agree with Justice Kagan?
Yeah, I agree with Justice Kagan on the apostrophe usage. No, I don't know. I don't know. But people, not me, but people have actually looked, like have studied, you know, Judge Kavanaugh's writing and clarity and rated judges on those kinds of things. But I haven't, you know, I haven't done that research. So I like the analogies. I like the Jack Daniels case. We read that
Last year.
Yeah, you did the nominative fair use. Garrett, do you remember? I know it was a whole year ago.
Yeah.
Yeah, but it was just, I like the creativity, the storytelling in the Supreme Court opinions. Those are,
That was
I
Justice Kagan.
yeah, I appreciate those most. Yeah, Garrett.
Is there a grammar mistake that bothers you most?
Yes.
What is it?
Well, there's 2 and they keep occurring. And I think my son, I think he's off, so I can criticize him. Yeah, I think he's off. Comma splices drive me crazy because it's a form of a run-on sentence, and it's a hiccup every time I read that. And periods and commas outside of quotation marks, which were not in Britain. So that error seems to be getting worse, not better. I don't know why.
Internet.
Huh?
It's the internet.
Is that it? Okay, yeah.
Other questions? Oh, Brian.
Or like when your colleagues send you emails. I'm often wondering if you're judging judging me for some.
Yeah.
But do you
The answer is yes.
do you
Yes.
treat, I guess my question is, do you treat emails in your mind the exact same grammatically as you?
I don't think I judge people. Is Professor Dysart still here? Okay, I do judge. I do. You know, I will notice it. And I notice that when people are not of my generation, like you aren't, and Professor Dysart is not, I find more of those things that, you know, I wouldn't have done that. But I don't judge you. Well, do I judge you?
Yes.
Yes.
Something the CLE that you do.
You will be an anecdote later. Yes.
Yeah, but I don't, because the reason why I don't judge is because I know it's stressful for me, you know, if I'm the grammar person, to make a mistake. That's scary for me because I'm supposed to, you know, be on my high horse and like, but I make mistakes too. But mistakes are important in learning, so. Anyways is another bugaboo of mine. I'm looking at Jack. But a lot of that generation says anyways. And I don't like that. Do you agree with that, Kate?
I just think people have not learned grammar or diagramming sentences for 40 years.
Right.
I think that's why writing is disintegrating.
Professor Dysart.
So, here's my question. Is technology killing or helping grammar? Because at times when you have criticized or commented, I tell you, I'm probably voice to texting and changing a diaper at the same time. And so, you know, that was a little ways ago, we're not in the students now. But does technology, how will technology impact grammar usage? What are your thoughts on that?
So I think originally technology or texting made everybody's grammar worse because you're not spelling out things, you're not using grammar and punctuation.
Teresa suggests to repeat the question. They may not have gone
Oh,
through to those on. the
Okay.
chat.
Do I think that technology is making things better or worse as to grammar and punctuation? So worse in some ways, but I think these new tools, the Grammarly AI now has an ability to help with grammar. My own, you know, my word editor fixes things for me as I'm typing. It says this is passive voice or you need a comma here. So that is very helpful to me. And I suggest you all use that. I mean, it's cheap. I mean, it's free and it is helpful and it corrects a lot of those errors.
So we have another question from Brielle. She says, now that you've written 2 books, what advice would you give someone considering writing their own first book?
I would say, write what you are passionate about and don't be afraid what other people will or will not think about your book and do it. I'm at the age, fortunately, where everything I do for myself and my own enjoyment. Nobody's telling me, well, except for she tells me all the time, but other than her, nobody's making me do any of this. And so it's much more enjoyable when you're doing it because you want to do it and you don't have to do it.
Any other questions before we? Right.
Yeah, that's a question for you as a litigator. I've come across so many opposition briefs that have the worst grammar I've ever seen in my life. I'm flawless, obviously.
Yeah,
But,
obviously.
I'm sort of wondering if there's a good way to like, because I know that stuff matters for, you know, credibility and that sort of stuff. How there's a way you can like target grammar weaknesses you see and like point that out to judges or something like that if they're not already noticing it.
Okay, so I don't know if you heard that question. Okay, so Vinny asked, he has seen briefs, he's now practicing, so seen a lot of briefs where there's a lot of errors in the briefs and grammar and punctuation errors. And is there a way to bring that to the attention of the judge? So I haven't practiced now for a while. But even the young me would not have ever brought that to the attention of the court. I think that would make me look petty and it'd be a petty snipe at my opponent. But I think I would know, Molly, maybe you can help us out clerking for the Arizona Supreme Court, that if you're reading that brief versus someone else's brief, that is, everything's perfect, citations are great, you might subconsciously trust the work of that lawyer more. And that's what I would say to myself. Like, I don't have to say anything. If those mistakes are being made, I'm going to have more credibility with the judge. Molly, anything to add?
No, I think you've got it. And I also think the example that you referenced of the criminal case where the conviction being upheld or reversed, maybe turned on a comma, I think that's a unique situation in which it is okay to bring up a grammar error because there's a substantive argument behind it. But yeah, I mean, I would say in my role as a clerk, I very much know when attorneys are making errors. And so I don't think it would add anything to have that explicitly brought to the attention of a judge or a clerk.
Okay, thanks.
I also think that as opposing counsel, there's nothing wrong with you mentoring that. I mean, obviously you're on opposite sides of the case, but it makes the profession better if maybe you have an opportunity casually to say, hey, like you might want to run spell check once in a while. Because I mean, I've actually had opposing counsel mentor me on different issues. Like I had no poker face, and during a deposition, after the case was over, opposing counsel said, you might want to watch your facial expressions. So yeah, there's nothing wrong with mentoring opposing counsel. Any other?
I'm guessing a lot of it's from the old parts, though.
Well, that's true.
Bad grammar, it's from the dinosaurs, right?
Yeah.
Yeah.
Can't confirm or deny, but yeah.
Yeah. Mentor.
That's true. That's true.
Okay, I just want to thank all the students who came to support me today. I really, really appreciate it. And former students, I've got two up here who are teaching and one's clerking. And anybody else that I'm missing? My colleagues who were always here. Okay, I think that's it.
Thank you.
Thank you.